Hello, my name is Amber Rouse Holloway, and welcome to the August 2022 episode of My PIP Monthly. Today we're going to be back to our original format, which includes, of course, the case law update. We'll be talking about the cases of Criswell v. Avis Rent-A-Car System, then Pellegrino v. State Farm, and lastly Al-Malaki v. Citizens Insurance Company. And as for trending topics in PIP litigation, I kind of wanted to revisit the topic of utilization reviews and give you guys a secret Wardle update on this specific topic because we've had some pretty good success in a number of courts throughout Metro Detroit. So I wanted to touch on that. I did have some questions regarding what areas or what courts we have had success with these types of motions. All right, first up, the case of Criswell v. Avis Rent-A-Car System. This is an unpublished opinion that was issued on July 28, 2022. Ultimately, in this case, the Michigan Court of Appeals upheld the trial court's order, which granted summary disposition, finding that the plaintiff unlawfully operated the rented vehicle that was owned by the defendant. The Court of Appeals held that rental car companies are the true owners of the rental vehicles, and the only person lawfully allowed to drive the vehicle is the person or persons who have signed the rental agreement. Not anyone else, not a friend that you let borrow the rented vehicle, not a family relative that you let borrow the rented vehicle. It is only the person who has signed that contract with the rental car company. I did want to give a brief background on this case. The case centers around a Pandora Hamilton's vehicle. Her vehicle was in the shop getting repaired, and during that time she rented a vehicle from defendant Avis. Ms. Hamilton was the only person signing the contract with Avis, and on the date of the loss, Pandora Hamilton was driving the vehicle with her cousin, plaintiff LaKenna Criswell, who is obviously the plaintiff. Pandora was not feeling well and could feel that her blood pressure was high. She had previous issues with this type of illness. So Pandora told plaintiff she needed to go to the emergency room, and the plaintiff and Pandora Hamilton switched seats in their vehicle, and plaintiff proceeded to the emergency room. While en route, the vehicle was involved in a motor vehicle accident with another motor vehicle. Thus, an action for no-fault benefits came about, and defendant moved for summary disposition under MCR 2.116C10, arguing that plaintiff was precluded from PIP benefits while operating the vehicle unlawfully pursuant to MCL 500-3113A and the signed rental agreement. It's important to note that MCL 500-3113A has three elements. One, the person was willingly operating the motor vehicle, the rented vehicle. Two, the rented motor vehicle was taken unlawfully. And three, the person knew or should have known that the vehicle was taken unlawfully. Here, the court argued that the first element was satisfied. Here, the plaintiff was willingly operating the motor vehicle. And two, the second element was satisfied because the owner of the vehicle, defendant Avis, did not give plaintiff permission to drive the vehicle. Lastly, the third element is satisfied because plaintiff knew the vehicle was a rental. So MCL 500-3113A indicates that the owner is the rental company, and it was taken unlawfully from the rental company because they were not aware that plaintiff was going to allow, not aware that Pandora Hamilton was going to allow plaintiff to drive the vehicle. Because of that, all three elements were satisfied. The Court of Appeals did, in this situation, turn away exigent circumstances, such as what plaintiff attempted to argue here, that Pandora Hamilton needed to be taken to the emergency room, stating that there was no exception in MCL 500-3113A that allows for exigent circumstances. Therefore, ultimately, the Court of Appeals held that rental car companies are the true owners of the rental vehicle, and the only person allowed to drive that vehicle lawfully is the person who has signed the rental agreement. Next up, we have the case of Pellegrino v. State Farm Mutual Automobile Insurance Company, which was issued on June 16, 2002. Now, this case centers around regarding in the context of plaintiff's claim for PIP benefits following a motor vehicle accident, and really delves into is evidence of the insurer's claims handling process admissible. Here, the Court of Appeals focused heavily on two issues. Number one, the definition of relevant information or relevant evidence under MRE 401, and number two, evidence necessary to hold a no-fault insurance liable for a particular expense. Taking these two factors into account, the court in Pellegrino ultimately affirmed the trial court's decision to exclude evidence of State Farm's claims handling. By way of background, plaintiff was involved in two motor vehicle accidents, one in December of 2016 and the other in August of 2017. After those accidents, she pursued PIP benefits, and she asserted that the accidents caused or exacerbated injuries to her neck and back. State Farm, however, asserted that plaintiff's injuries were a product of degenerative conditions, and this dispute led to a jury trial during the midst of the COVID-19 pandemic. During the trial, several COVID-19 protocols were implemented, which included voir dire of the jury via Zoom, as well as strict social distancing and mask requirements. But at the conclusion of a 3-day trial, the jury determined that Ms. Pellegrino's injuries did not arise out of either accident, and as a result, a judgment of no cause in favor of the defendant was entered. Thereafter, Mrs. Pellegrino's attorneys filed a JNOV, which stands for a judgment notwithstanding the verdict, or they asked for a new trial. Within the motion, plaintiff argued in relevant part that the jury's verdict was against the weight of the evidence. Plaintiff also argued that her right to a fair trial was violated by the court's implementation of the COVID-19 protocols. The motion was denied by the trial court and plaintiff appealed. And here we are on appeal. Plaintiff asserted that the trial court abused its discretion by excluding evidence of or reference to defendant's handling of the claim. And this is the main issue regarding this unpublished opinion. According to the plaintiff, the evidence of the claims handling was relevant to three things. First, whether she suffered a bodily injury. Second, whether defendant should have paid PIP benefits. And third, whether defendant was unreasonable in their refusal to pay the claim. The court did deny plaintiff's argument and opined that relevant evidence under MRE is evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. The court concluded that evidence of how defendant processed the claims handling was not relevant under MRE 401. Specifically, the court opined that evidence regarding how defendant processed plaintiff's claim for benefits would not have a tendency to make it more probable or less probable that plaintiff's injuries arose from the use or operation of a motor vehicle. Therefore, it would not be relevant. This is an important case because it does emphasize a basic but very important principle that in the context of a question as to the admissibility of evidence or the relevancy of the evidence. Ultimately, the court in Pellegrino conceded that evidence of an insurance claim handling may be relevant to an award of no-fault attorney fees or to the recovery of penalty interest, but the court clarified that such evidence is not directly relevant to plaintiff's recovery of PIP benefits, and that's an important distinction to make. And next up, we have the case of Al-Malaki v. Citizens Insurance Company, which is an unpublished opinion issued on June 23, 2022. Here, the case centers around whether recorded statements with insurance adjusters, even when unsworn, are party admissions under the Michigan Rules of Evidence 801D2 and not mere hearsay. Here, the court opined that the statements made in this matter were admissible as non-hearsay because they were admissions by a party's opponent. They were admissions by plaintiff himself. Because plaintiff was a party to the suit, Citizens used these statements made against her, and because plaintiff had not disputed the statements, they constituted admissions by a party opponent and were not hearsay. So I don't feel it's necessary to give a full background regarding the facts of the matter, but the relevant facts are that after a motor vehicle accident, the plaintiff the insurer did obtain a recorded statement with the citizen's adjuster from the plaintiff. This was about 2 months after the accident. And during that recorded statement, plaintiff admitted she was the sole owner of the vehicle, that the vehicle was uninsured, and that she knew it was uninsured when she drove it on the day of the accident. Therefore, this satisfied the court's opinion or conclusion that the statement that the plaintiff was a party to the suit. Citizens used the statements made against her, and because plaintiff did not dispute the statements, they were admissions by a party opponent, and therefore not hearsay and can be used as party admissions. Right, on to utilization reviews, a Secret-Swarto update. As you guys know, when the legislature passed the Comprehensive No-Fault Reform in June of 2019, it enacted NCL 500-3157A. This enabled no-fault insurers to conduct these utilization reviews of medical provider charges. These utilization reviews sometimes come to the conclusion after a preponderance of evidence that the provider overutilized their treatment. Whether it's too much treatment occurred and it's outside of the industry standards for whatever specific injury the plaintiff or claimant has, and based on that, it was outside of the medically accepted standards or overutilized treatment. And then under the no-fault reform, the Department of Insurance and Financial Services was instructed to establish criteria and standards for utilization reviews that identify utilization of treatment, products, services, or accommodations under this chapter above the usual range of utilization of the treatment. So that's more of a wordy way, and probably a correct way to say how I initially described it. But on December 18, 2022, DIFS enacted the utilization review rules, which became a part of the Michigan Administrative Code. Ultimately, it says that defendant may determine through its utilization review that a provider overutilized treatment, and as such, defendant would then advise the provider that it would no longer be providing reimbursement for the services at issue because the treatment has been overutilized. And then Michigan Administrative Code R 564-3 provides that an insurer's denial of a provider's services on a basis that the provider overutilized or otherwise rendered inappropriate treatment is a determination from which the provider may appeal to DIFS. The Administrative Code also states that a provider may appeal the determination made by an insurer within 90 days of the date of the disputed determination, and the same must be made on a form prescribed by DIFS. So basically, after the insured conducts this utilization review, the provider has 90 days to dispute it and must use a form that the DIFS has created and provided. If the provider fails to do this appeal, it is our position that the provider did not act in accordance with Michigan Administrative Code and NCL 500-3157A. If the provider did appeal the determination with DIFS, a decision issued by DIFS would be subject to judicial review under the Michigan Administrative Procedures Act. Now, under case law, when an administrative scheme of relief exists, a party must exhaust that remedy before a circuit court has jurisdiction over the case. The phrase exclusive jurisdiction need not appear in a statutory provision in order to find that jurisdiction has been vested exclusively in an administrative agency. So here it's basically saying that the provider must exhaust all relief that is provided by administrative scheme. So if a provider does not do this, then the court does not have jurisdiction over the case yet. So basically, if the provider does not appeal, there's no genuine issue of material fact that the services are not overdue, and therefore the plaintiff does not have standing to maintain the cause of action. So here, we filed this motion using this case law and these arguments in Macomb County, the 16th District Court, 36th, 37th, and 48th District Courts. So a lot of success in the district courts around Metro Detroit, and a few instances of success in Macomb County. Now what we've seen is normally it's partial disposition of the claim. So for whatever bills have been reviewed through the utilization review process and not the entire claim. Now, a lot of claims you see that the insurer has had the majority of the bills, the majority if not all of the bills have gone through the utilization review process. So if that's the case, then the entire case is disposed of. But if it's only the case where the physical therapy bills and not the pain and medicine, the pain and medication bills haven't been reviewed, then it would be the case that only those physical therapy bills can be disposed of through summary disposition in this manner. And I hope that answered some questions for you guys regarding the summary dispositions on the utilization review process. Ultimately, a provider has to exhaust that administrative relief if they want their case to remain, or if they want to say that benefits are overdue. And that's all we have here for the August 2022 episode of My PIP Monthly. Please feel free to contact me with any questions and or concerns. Thank you.